Loud and clear, over.
Everyone.
All the way.
Okay, good morning, ladies and gentlemen. Welcome back to Bexar County Court at Law number 6 in the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian, and today we have two motions to revoke probation hearings. It is approximately 10:25 a.m. on Wednesday, the 28th of September, 2022. And the cases I have on my docket are State of Texas versus Ariel Gonzalez, cause 6877743, represented by Miss Suzanne Kramer. And this is a motion to enter adjudication of guilt and revoke community supervision. Are you ready to proceed, Miss Kramer?
She is in a breakout room with her client, Your Honor. Ms. Morgan is ready.
Father, Miss Morgan. The next case I have is cause 668254, styled State of Texas versus Tara Best. And this is a motion to enter adjudication of guilt and revoke community supervision. And are you ready to proceed, Ms. Morgan?
I'm ready, Judge. And just to clarify, is she on deferred or is she on, I think she's on straight probation.
You know, I don't know, but my motion to enter adjudication of guilt, obviously thinks she's on deferred. Ms. Gross, you want to advise us on that one?
Miss Best, it does appear that she is on regular probation with a 1-year underlying sentence.
All right, so this is administrative error on your motion to enter
And
adjudication
there
of guilt.
should not be a 0.15 or higher. It should be a 180-day term.
All right, so is it a DWI first, Ashley?
It is a DWI first. Her blood was her blood was a 0.05, so there's no 0.15 or higher.
So is she on probation for a DWI first, class B, or a DWI first with a 0.15 or greater blood or breath test, class A?
It should be a DWI class B.
Right.
I'm looking at her application and KPI right now, Judge. Hold on.
And I have her in the system. I think they must have had an error going on.
I have the KPI says driving while intoxicated, $500 fine plus court costs, 48 hours community service, DWI ed, dip, smart start or lifesaver for 6 months, catnip. And I'm showing that she was put on probation for 1 year. She pled no contest to DWI on 15 June 2022.
That's
Okay.
correct, Judge.
So Ms. Morgan, and let me back up a second. Representing the state in all matters is Assistant Criminal District Attorney John Sanheinrich. In this particular case, representing Ms. Best is going to be Ms. Ashley Morgan, and representing the Bexar County CSCD is Ms. Susan Gross, who I will swear at this time. Please raise your right hand, Ms. Gross. You swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
Okay, so Ms. Morgan, over to you. We can defer this entire hearing until the probation department correctly provides a motion. It would be a motion to revoke community supervision. We all agree?
Yes, Judge.
Or you can waive that and agree that we will have the actual document conformed to what it should be after this hearing. You can do it any way you want.
Yes, Ms. Best would like to move forward today. She would like to plead true with an explanation.
So it's my understanding that everyone agrees that this should not be a motion to enter adjudication of guilt and revoke community supervision filed against Ms. Tara Siobhan Best in clause 668254. It should be a motion to revoke community supervision. Is that correct, Ms. Morgan?
Yes, Judge.
And State, do you agree?
State agrees, Judge.
And Ms. Gross, do you agree?
Yes, Your Honor.
All right. So Ms. Gross, is it okay with you and okay with the state if we go ahead and hear this motion, knowing it's a motion to revoke community supervision and not a motion to enter adjudication of guilt and revoke community supervision? And Ms. Gross will reprocess the paperwork so that it accurately is in the proper form. Is that okay with you, Ms. Gross?
Yes.
And State, is that okay with you?
It's okay with the state, Judge.
And Ms. Morgan, is that okay with you?
As long as everyone's under the same understanding that it's not a subsequent motion to revoke probation with the warrant and back here again on the same issues.
I agree. In other words, Susan, this is basically an administrative correction. We're not going to file a new motion to revoke probation. We all agree?
We do, Judge.
Yes.
Can we do that, Susan?
If we file new paperwork through the clerks, then it's going to get issued as a whole new MTR. So I would say we just verbally amend it here and leave it as is and make corrections moving forward.
All
I
right,
agree,
so what you propose, we just draw a line. In other words, I will draw a line through motion to enter adjudication of guilt and revoke community supervision, or at least the parts that say to enter adjudication of guilt, and it's just going to say motion to revoke community supervision and initial it. Would that be okay with you, Ms. Morgan?
Yes, Judge. I was worried it would generate
Right.
an entire new MTR.
And that's okay with you, Mr. Sandheinrich?
It is, Judge.
And Susan, that's okay with you?
Yes, Your Honor. We'll just
right.
make sure that everything is correct moving forward.
Your Honor, and if all of you agree, what I could do is just annotate it on the D page that this was agreed upon,
It's okay with the state, Ms. Pat.
just to have some kind of record that it was done.
Well, I mean, we're in the middle of having a record right now,
Okay,
so
all
we're all
right,
good.
Judge.
As long as everybody agrees. If anybody disagrees, they need to speak now or forever hold your peace. Last time somebody did that, I got married. Oh, no, we'll go there. All right. So let's start over. This is called 668-254, State of Texas versus Tara Siobhan Best. This is a motion to revoke community supervision. And once again, representing Ms. Best is Ms. Ashley Morgan, representing the state is Mr. John Sandheinrich, Assistant Criminal District Attorney, and representing the Bexar County CSCD is Ms. Susan Gross, who had been previously sworn. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Ms. Best's signature and Ms. Morgan's signature on it. In fact, Ms. Best, is this your signature on this document?
Yes, it is, Judge.
Thank you, ma'am. And Ms. Morgan, is this also your signature on this document?
It is, Judge.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. And it's improperly marked at this time because I have it marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. And we're going to mark that out and I will initial it and mark the correct one, which says, quote, is a revocation of the defendant's community supervision and the defendant has the right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. Ms. Morgan, is that okay with you?
Yes, Judge.
And state, is that okay with you?
It is, Judge.
All right, so Ms. Best, in clause 668-254 on the trial court certification of defendant's right of appeal, is this your signature on this document also, ma'am?
Yes, Your Honor.
Thank you. And Ms. Morgan, as attorney for Ms. Best, is this also your signature on this document?
It is, Judge.
Thank you. All right, now we get to the motion to revoke community supervision. And Ms. Morgan, my understanding is this is going to be an uncontested motion to revoke community supervision, although the defense may plead not true to certain allegations. And you're not requesting a formal contested motion to revoke community supervision. Is that correct?
That's correct, Judge. We would like to plead true with an explanation.
All right, all good. Therefore, Ms. Best, in clause 668-254 on the motion to revoke community supervision, how do you plead, ma'am? And Ms. Morgan, you can go ahead and clarify it for her if you would, if it's going to be
She's going to plead true with an explanation, and may I proceed on the explanation?
All right, so true with an explanation, all, would that be accurate?
Yes.
All right, fair enough. Ms. Gross, would you please advise the court and the parties of the status of Ms. Best's probation? I remind you, you're still under oath.
Yes, Your Honor. Ms. Best has been reporting as directed. We last saw her September 21st, 2021. We've not received any payments to date. She has a balance of $1,380 and is currently delinquent $413. We don't show that she's completed any of her 48 hours of community service. She has completed DWI education, victim impact panel, and we show no proof of completion of the CAPSNP program. She has had 2 positive drug tests for marijuana, and she's currently on Smart Start Mobile, testing 4 times per day. And as alleged on the motion, she had 19 skip tests. And since she obtained a new device last 10 days, she has had 5 additional skip tests. She has not had any high bracs. Her arrest history includes an arrest for possession of dangerous drugs, possession of marijuana, 2 to 4 ounces, assault, bodily injury, married, and possession of a controlled substance, penalty group 2, less than 1 gram. Her officers recommending that she be continued on probation, and she switched to a LifeSafer device. and that she find full-time employment so that she can meet the court's obligations for payments.
Ms. Morgan, what are you requesting?
Judge, all of those previous arrests have been dismissed. She has no other convictions. This is the case. I believe I first approached you on it in court on September 7th. I pulled the file and I conferred with Mr. Standerich and as well as you as well. 10 of those skip tests, her device, her Smart Start mobile device was not in her possession. The device was stolen from her vehicle on July 30th. She contacted her probation officer and relayed this information. And the probation officer instructed her that she was going to contact you. And at that time, we learned, I believe the warrant was issued on August 25th. So there was no working with the probation on trying to get her on the LifeSafer device until she reached out to me. Once that warrant went live, and we knew about it, I made a mistake and I told her to get an Intoxilock. I got confused with the different devices. So she did originally get an Intoxilock for some of that time. And then I contacted Ron when I realized my mistake, and she was switched to a LifeSafer. She's
Let me stop you there real quick. She's now currently active on LifeSafer at 4 blows a day. Is that correct?
I believe they have her on 6 blows a day, and that's what we're asking. Yeah, that we're gonna ask her for 6 blows a day for the next 30 days.
Ms. Best, are you on 4 blows or 6 blows right now?
6 blows, Your Honor.
All right, go ahead, Ashley. Thank you.
And this is also the individual who received a diagnosis for PTSD, and so she believed she was legally ingesting marijuana. I've since explained to her the court's policy, and she has agreed to cease ingesting marijuana. She was positive, and so she is working down on her levels. She did a UA on Friday, the 21st, which we believe will be positive. So we don't want the court coming back with another motion to revoke her probation based on that. But she has quit and her levels will be going down. And so she's asking the judge, or she's asking you to give her a chance to continue her probation, allow her to do 6 blows a day for the next 30 days with weekly or monthly UAs, with the understanding that she's going to be positive for a bit.
Okay.
Do you want to add anything else?
Thank you. State recommendation?
The state's still concerned with the skip test between September 17th and the 25th after I believe the LifeSafer device had been procured. At this time, Judge, the state would recommend that Ms. Best be placed on a Scram device, be continued on probation, and be required to obtain full-time employment in a time frame that the court deems reasonable so that she may meet her probation obligations, Judge.
Judge, I would ask you to reconsider that Scram. She is having a hard time meeting her financial obligations, and this would add an additional $350 per month obligation. She's never had a positive UA for alcohol. Her blood on the underlying offense was a 0.05. Alcohol is not her issue. She's never drank or proved, she's never had a high BRAC violation.
Okay. I feel bad because if I tried to order Ms. Best to do Scram, which would be the textbook solution, I've already basically been mean to Ms. Morgan and Ms. Best and made them jump through hoops to get on the right device. So I can't in good conscience order on a Scram device right now, but I can warn both Ms. Morgan and Ms. Best if there are any further problems, that's where I'm going. So right now we're good on LifeSafer at 6 blows a day. Have you been on that more than 30 days, Ms. Best, at this point in time at 6 blows a day? No?
No, Your Honor. I just got the LifeSafer on
Okay.
Friday the 23rd.
Once you have been on the LifeSafer device at 6 blows a day for 30 days and you haven't missed any test, skipped any blows, and there are no high BRACs for alcohol, I'll crank you back down to 4, but I won't know you've done that. So you got to let Miss Morgan know. She'll let me know, and I just send an order into probation and they'll fix that. I'm going to keep her on weekly UAs and we'll watch the marijuana count. I would like to thank both Miss Morgan and Miss Best for volunteering to come off of medical marijuana because that caused everybody a lot of grief. And I appreciate you doing that. And that solves one of my big issues on this case. So we've taken care of that. Once you've done 4 UAs, I'm going to take you off of that. I know they're going to be positive for marijuana. We all know that. I just want to watch the nanogram count if we can. And then we'll put you back on monthly UAs after you do the 4 from this point forward. Is that equitable to the defense, Ms. Morgan?
Yes, Judge. And will you withdraw any scram orders
Yeah.
that were?
We're going to recall any and all pretrial services, bond conditions, and warrants, that kind of thing. Also, I'm going to order her to have substantial compliance within 10 days. And by that, I mean, any program she's not signed up for already, she needs to be signed up for within 10 days. I understand she probably won't start all these different programs within 10 days, but she needs to know what's coming. And I'm primarily interested in the catnip outpatient drug course. Did she do the DWI education and the victim impact panel proactively before she ever went on probation?
I don't think so, Judge, but those are both completed.
She's done those too, though, is my understanding. So we're good on those. Susan, what did I forget?
The only other issue that the officer is concerned about is her employment. Does the court wish to address that?
Sure. What's going on with your employment, Ms. Best? Do you want to be employed, or are you independently wealthy, or what's going on?
I'm self-employed, Your Honor. I own a food truck and I work full-time.
Okay. How much money a month do you make with your food truck?
It varies, but about $3,000 to $4,000 a month.
All right, Susan, that's a job. If she can give you guys a warm, fuzzy feeling, that's as good a job as any I know of.
Okay.
So if you, I mean, I don't know what kind of proof you would, can you take them a tax return or copy or something that shows that you're working? Would that be okay?
I have emailed my probation officer. I get a check monthly from Grubhub, one of the delivery apps that gives my food out, and I have sent that to my probation officer as recently as last week.
All right, well, that's okay with me. If it's okay with the probation officer. Susan, is that okay with you?
That's fine. But we just need you to start making some payments because you haven't done that yet.
I understand, Judge. Last month,
Ashley, go ahead, ma'am.
Last month, you signed off on a financial review, allowing me to complete more community service hours in lieu of paying payments. I don't know if you recall that, but we can go back in the records.
How many community service hours have you done so far?
I haven't yet. Because of the warrant, I was afraid that I was going to get picked up on that, Your Honor. All
right. Well, let's put that on the front burner. And within 30 days, I want to see substantial compliance on you doing something on the community service side. That fair?
Yes, sir.
I mean, I don't expect them all to be done, but I expect you to be doing at least 10 or something. Is that okay?
Yes, sir. I understand.
All right. Ashley, is that okay with you?
That sounds good, Judge. Thank you.
And John, is that okay with you?
That's okay with the state, Judge.
All right. Ms. Baston, cause 668-254. The court accepts your plea of true with an explanation on the motion to revoke community supervision. I deny the state's motion to revoke your community supervision. Order you continued on community supervision with all prior requirements and no sanction at this time. Altering and amending conditions, ordering you to stay active on a Life Safer mobile, currently at 6 blows a day. And once again, once you've done 30 days on the Life Safer mobile at 6 blows a day without missing any blows and no hybrax for alcohol, please tell your attorney. She'll tell me, and we'll crank you back down to 4. I'm putting you on weekly UAs, knowing they're going to be positive for marijuana at this time. And show me 4 UAs, and I'll have a good idea where we're going with this, and I'll put you back on monthly UAs. Ordering substantial compliance within 10 days. We discussed that. Anything you're not registered for with the way of programs and community service and stuff, you need to get registered for and start doing. And that's what I got. Susan, what did I miss?
I think that'll cover it. And Ms. Best, after I'm done here, I'll be sending you some paperwork via your email. It will be your alternate amended conditions. Just sign those, return them back to me, and then also give your officer a call and let her know that you did have your hearing this morning and what transpired, okay?
Yes, ma'am.
And then she'll get you set up on the month or on the daily call-in line for your drug testing.
Have you got any questions, Ms. Beth?
I'm sorry, Miss Susan just said daily UAs. Did she mean weekly?
No, you're going to call daily and it's going to tell you what day you have to pee.
Okay. Yes, ma'am. I understand.
They're supposed to be random weekly UAs, so you don't know if it's going to be on a Monday or a Tuesday or a Wednesday. So you call in every morning and they may say on Monday morning, no, don't come in. And on Tuesday, they may say, yeah, come in by 4 o'clock or whatever time they tell you. Is that right, Susan?
Yes.
All right. Is that okay, Ms. Beth?
Yes, sir.
All right. Ms. Morgan, anything further?
Nope, Judge. Thank you.
All right. Thank you, Ms. Beth. Thank you, Ms. Morgan. Y'all are excused. And we got Ms. Kramer with us. We do. Ms. Kramer, are you ready to proceed on Ms. Gonzalez case?
I am, Judge.
Cause number 687-743, State of Texas versus Ariel Gonzalez. This is a motion to enter adjudication of guilt and revoke community supervision. Representing the state, once again, Mr. John Heinrich, representing the Bexar County CSCD, Ms. Susan Gross, who I remind is still under oath. The first document I have in this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Ms. Gonzalez and Ms. Kramer's signature on it. In fact, Ms. Gonzalez, is this your signature on this document, ma'am?
Yes, Your Honor.
Thank you. And Ms. Kramer, as attorney for Ms. Gonzalez, is this your signature on this document?
Yes, Judge.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. Is this your signature on this document also, Ms. Gonzalez?
Yes, Your Honor.
And Ms. Kramer, as attorney for Ms. Gonzalez, is this also your signature on this document?
Yes, Judge.
Ms. Kramer, my understanding is that this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, Judge, but based on my conversation with Ms. Gonzalez, we're willing to plead true to number 2 and 14, and then I can speak to you about the other allegations.
Fair enough. So Ms. Gonzalez, my understanding is you're going to plead true with an explanation to condition 2, which talks about consuming alcohol on or about September 12th, 2022, and 14, which says that basically that just confirms the same alcohol positive, except it gives us a 0.051 result. Would that be accurate, Ms. Kramer?
Yes, Judge, and also she has not registered for the CATS class, so true to that one as well.
And that would be number
16.
16.
I'm sorry, Judge, 16. Yes,
All right, so 2, 14, and 16 with an explanation. Would that be accurate?
yes, Judge.
All right. Ms. Gross, would you please advise the court on the parties of the status of Ms. Gonzalez's probation?
Yes, Your Honor. Ms. Gonzalez has only been on probation since August 30th of this year. So she's not yet had her first appointment. Her first appointment is scheduled for tomorrow. She's paid $128 towards her fees. She has a balance of $999 and she's current at this time. We don't show any of her 30 hours of community service having been completed, but I would imagine she'll be referred to a location tomorrow when she reports. Because she has not yet reported, we do not have any drug tests on file. She has completed victim impact panel, and we have no proof of enrollment or completion of DWI education or the CATSNP program. She is currently on a PAM device where she is testing 4 times per day. She's had 10 skip tests and 1 high BRAC. She had a high BRAC of 0.051 on September 12th, 2022, and she failed to provide a retest to blow that to clear. She has 1 prior arrest for possession of marijuana less than 2 ounces. This is her first violation report, first MTR, and her officer's recommending that her PAM device be increased to 6 times per day and that she be registered for the CATSNP program within 10 days.
What PAM device specifically is Ms. Gonzalez currently active on?
She is on Intoxilock.
Okay. I got Ms. Kramer, go ahead.
Yes, Judge. As far as the MTR doesn't reflect any skip test allegations, what Ariel tells me as on that day of, I think it was September 12th, when there was an alcohol blow, she says she got no notification to blow again. Further, her probation officer, Fonseca, had been talking to her about these skip tests, and she was telling him she didn't skip any tests. So what she did the day before she turned herself in was she went and got a new machine. So because this one was, she had, documented with Fonseca that it was not operating well. So she is fixed that problem. She is registered. She has done VIP. She is not registered for CATS, but she has registered for DWI Ed. She just hasn't completed it yet. As far as the community service, she wanted to see if she could possibly buy out of some of those hours. And I told her, not being remote, I don't have the Wounded Warriors list, but the court, Pat could send it to me and I could send it to her.
State recommendation.
Judge, we're worried, state's worried about the high BRAC, about given about 12 days after the adjudication. The state is asking that the defendant be adjudicated guilty, that the blows increase to 6 a day for a reasonable period of time, that the defendant become substantially compliant, and that she register for the CATSNP program within a reasonable period of time, and that the defendant be continued on probation.
And Judge, since she hasn't even been on probation for a month, and I understand, and I talked to Ariel about the 0.051 on the machine, but because the machine was malfunctioning and she did not do a confirmation reblow, we don't really know how accurate that is. So at this point, I think that it would be fair, you know, obviously I'm fine with her being up to 6 blows a day and substantial compliance on the classes that she needs to do and community service. But I think taking away her deferred this early in the game would be not very fair to her, and give her one more chance and see if she is able to do this per the judge's orders.
Ms. Gonzalez, are we going to have any more problems, ma'am?
No, Your Honor.
Good answer. Ms. Gonzalez, in clause 687743, the court accepts your plea of truth and explanation to conditions 2, 14, and 16 on the motion to enter adjudication of guilt and revoke community supervision. I deny the state's motion to revoke your deferred adjudication probation, or to continue on deferred adjudication probation with all prior requirements, and no sanction at this time, although I have the authority to give you a 30-day jail sanction to get your attention. Will that be necessary?
No, Your Honor.
Thank you. Alternate amending your probation conditions to continue you or to increase your blows on the Smart Start mobile device from 4 blows a day to 6 blows a day. If you do that for 30 days without missing any blows and no high BRACs for alcohol, I'll crank you back down to 4 blows a day, but I won't know you've done that. So if that happens and you do good, let your attorney know, she'll let me know, and then I'll contact probation, let them know we're cranking you back down to 4. I'm going to put you on weekly UAs. Show me 4 clean weekly UAs, and I'll put you back on monthly UAs. Once again, I will not know you've done that if you've done it. I'm ordering substantial compliance in all other areas. I understand you've only been on probation plus or minus 30 days. Within 10 days from now, I want you registered for all programs. You may not start them, but at least you'll be registered and you know when they start, and you can plan to do that. Your probation officer has a list of recommended court charities with regard to donating $10 a month for community service hours, primarily special operations, wounded warriors, and family violence prevention organizations. You're welcome to use those. And that's what I got. Susan, what did I miss?
I think you covered everything, Your Honor.
State, what did I miss?
Got it all, Judge.
Ms. Kramer, is that equitable to the defense?
Sounds good to me, Judge.
All right, Ms. Gonzalez, we got to stop meeting like this, okay? Stay cool. You're going to be fine. All right. Y'all are dismissed. Thank you.
Thank you, Your Honor.
Hang on, Ms. Gonzalez, I'm going to be emailing you a document in a little bit. It'll be your amended conditions. You need to sign it via Adobe Sign and then send it back. And then also contact Mr. Fonseca, let him know that you were in court this morning and that you also need to be set up on the IVR call-in line for the weekly UAs. And I'm going to send him a message too, but I still have some business to address here. So you can probably get a hold of him before I will. Okay.